let's talk about something that feels a bit like a tug of war. You've got your right to data privacy on one side, and on the other, you have HMRC's power to check up on your taxes. So where's the line drawn? Well, we've teamed up with the experts over at My Tax Accountant to put together this guide, where we're going to give you the playbook to navigate this pretty complex area and really understand your rights.
Right. Picture this. That dreaded brown envelope from HMRC lands on your doormat. Your heart probably does a little flip, right? But as you open it, there's a really crucial question you need to ask yourself. In this exact situation, what are your data rights? Do you actually know where the line is?
That's exactly what we're here to do today. We're going to demystify all the rules specifically for the 2025 to 26 tax year. And honestly, by the end of this, you are going to have a much clearer picture of your rights, and you'll be way better equipped to handle any kind of communication from the taxman.
Okay, let's dive in. Here's a quick look at what we're covering. We're going to start with the big picture: HMRC, GDPR, and you. Then we'll get into the nitty-gritties of their powers versus your rights, look at a really interesting court case, and wrap up with the key rules you need to know. So right at the heart of all this is a fundamental conflict. I mean, think about it. HMRC needs your information to make sure the right amount of tax is being paid. But you, under UK GDPR, have a basic fundamental right to privacy and control over your personal data. So how on earth do these two powerful principles actually coexist?
The easiest way to think of it is like a classic battle. In one corner, you've got your data shield. That's the UK GDPR, protecting your personal info. And in the other corner, HMRC is wielding its investigative sword. That's the Finance Act, which gives them the power to probe your tax affairs. And today, we've got a ringside seat for this epic clash.
First up, let's take a closer look at that investigative sword. What legal tools does HMRC actually have in its toolbox to gather the information it says it needs?
You know, HMRC isn't just asking nicely. They have some serious legal muscle to back up their requests. And these powers are properly written into law, all to make sure that everyone is paying their fair share.
Now, the main weapon in their arsenal is something called a Schedule 3.6 notice. It is absolutely crucial to understand this is not just a casual letter. It's a formal legal demand. If you get one, you are legally obliged to respond. But, and this is a big but, their power isn't limited. Notice those two key words, reasonably required.
So what's actually fair game for one of these notices? Well, they can ask for specific documents and information about your taxes. And they're not just limited to you. They can go straight to your bank or your accountant too. But here's that crucial limit again. Absolutely no fishing expeditions. They can't just cast this huge wide net and see what they catch. The request has to be targeted, it has to be relevant.
Okay, so we've seen HMRC's sword. Now let's talk about your shield. What powers does the UK GDPR give you to protect your data? Your most powerful tool here is what's called a Data Subject Access Request, or a DSAR for short. This is your fundamental right under Article 15 of the UK GDPR. It lets you ask any organization, and yes, that absolutely includes HMRC, for a copy of all the personal data they hold on you. It is your right to see what they have. And here's a little pro tip for you. A DSAR is actually more than just satisfying your curiosity. It's a vital tool for transparency. By seeing the data HMRC holds, you can start to figure out whether they're processing it lawfully and fairly, which, is a huge cornerstone of your data protection rights. All right, this is where it starts to get a bit tricky. We've got HMRC's need to investigate on one side, and your right to access your data on the other. What happens when these two powerful forces collide head-on? Well, the law actually has a built-in exception for this exact scenario. It's a clause in the Data Protection Act, and it allows HMRC to bypass some of your data rights when it comes to assessing or collecting taxes. But, and this is really important, this isn't a get-out-of-jail-free card for HMRC. They can't just wave the tax flag and deny you access to everything. They have to prove that giving you the information would actually harm their investigation. This is called the prejudice test, and it's a pretty high bar for them to clear. They have to show that you seeing the data could genuinely compromise their work, for example, by tipping you off to hide assets or something like that. So how does all this theory play out in the real world? Well, let's look at a fascinating high court case from just this year that put these rules to the ultimate test. The case involved a Mr. Ashley, who was hit with an additional tax bill for a staggering £13.6 million.
Wow. In response, he submitted a data subject access request to try and understand how on earth HMRC had reached that figure. I mean, the stakes don't get much higher than that, do they?
So the High Court found that HMRC's handling of this request was, well, deeply flawed. First, their search was totally inadequate. They only looked in one department even though they knew others held relevant data. Second, they just applied this blanket tax exemption without justifying how each piece of withheld data would cause any prejudice. And third, the data they did provide was redacted, blacked out, so heavily it was completely useless. Stay with me. The next point might surprise you. The court's conclusion was a massive reinforcement of your rights. It declared that the right of access isn't just some minor procedural thing, it is a fundamental right. It's the gateway that lets you exercise all your other data rights, like the right to have things corrected or even erased. This ruling sent a really clear message that this right just cannot be brushed aside lightly. So, what are the key takeaways from all this for you? I mean, whether you're a freelancer in London or a small business owner in Manchester, what does this actually mean? Let's break down the rules of engagement. This table sums it up perfectly. HMRC can request information that's reasonably required. They can restrict your access to data if it would genuinely prejudice their investigation. But they cannot go on a fishing expedition. They cannot apply a blanket exemption without specific, solid reasons. And they absolutely cannot provide you with data that's so heavily blacked out it makes zero sense.
Okay, before we finish up, just a quick but really important note. All the information we've discussed today is for general guidance. For advice tailored to your specific situation, it's always best to consult a professional.
And that really brings us to a final, critical question. If that brown envelope does arrive and you suddenly find yourself facing an inquiry, are you confident about what to do next? Look, the crossover between tax law and data privacy is incredibly complex. And as that High Court case showed, even HMRC can get it wrong. For advice that's tailored to your specific circumstances, you really should consult the experts. The team at My Tax Accountant are specialists in this field. You can reach them by phone on 020-857-8531, or you can drop them an email at info@mytaxaccountant.co.uk.